Good afternoon, officer.
Good afternoon, sir.
It's your testimony that you conducted an inventory search in this case, correct?
Yes, sir.
And you performed the inventory search prior to the vehicle being towed, right?
That is incorrect.
Oh, it being impounded?
I conducted the inventory search once the vehicle was impounded.
Okay. I'll rephrase. You conducted the inventory search pursuant to the car being impounded.
After the car was impounded, yes.
It's the department's policy that when a car is impounded, it needs to be inventoried.
Correct.
And so there are policies from the Detroit, what is it, the police, Detroit Metro Airport Police issue some policies regarding inventory searches.
Yes.
And those policies provide that when a car is being impounded, it needs to be inventoried.
Yes.
Okay. You said that you, well, I don't think you said, but you started the search at the passenger side of the vehicle, right?
I don't
Objection,
recall.
assuming facts not in evidence. That was never mentioned today.
I don't know.
Objection is overruled. You may answer the question.
I don't recall.
Okay. Just a moment. Officer, your testimony earlier was that the car is impounded.
Yes.
And it was impounded. I think your testimony is that it was impounded when you conducted your search.
Yes.
And let's talk about the definition of impound. When we say impound, that could be as simple as lifted up onto the back of the tow truck.
I'm not sure what your definition is, but the departmental policy is as soon as the tow truck makes contact with the said vehicle, it is impounded.
Okay, thank you. That's my question is not as to my definition, but as to yours. So in this case, the tow truck had made contact with the vehicle in question.
Correct.
And I believe that your testimony earlier was that you don't remember whether the car had been lifted up or not. Is that correct?
Correct.
But you just remember that there was enough contact.
I remember it was impounded.
Okay. And you don't remember the order of what you searched first?
No, sir.
Do you remember where you found the gun?
Yes.
You found it in the center console, correct?
Correct.
And that center console was closed when you found it in the center console?
I don't recall.
Okay. Do you recall whether you were entering the vehicle from the driver or passenger side?
Objection, relevance. I was, and knowing which side you entered the vehicle to conduct this inventory search relevant.
Judge, I think that the procedure that the officer is following when conducting inventory search is highly relevant. The officer testified that there is a policy, and so I'm just wanting to get a little bit more of a sense of how the inventory search is conducted and whether it's conducted according to policy.
Your objection is overruled. You may answer the question if you recall the question.
I do not recall which side I started on.
Okay. During your search, you crossed paths with a pair of designer sunglasses.
Objection, relevance.
I don't believe that Mr. Sullivan was done with his question yet. Mr. Sullivan?
Thank you, Judge. My question is that at some point during your search, you came across a pair of designer sunglasses. Is that correct?
I don't recall.
Is there a list that you can refer to?
Not on me. I do not have one.
Did you generate a list in the process of conducting the search?
There was a tow tag generated.
So let me ask the question a different way. As you went through the vehicle, did you make a list of the things that you found in the vehicle?
I don't recall, but I should have, yes.
You are testifying that you should have made a list of the things that are in the vehicle.
I don't have the tow tag in front of me, so I can't testify to it.
Okay. You would agree with me that your policy is to complete a tow tag?
Correct.
And if a tow tag is not completed, that would be in a violation of your policy.
I can't speak to that.
Well, you just testified that it's policy to complete the tow tag.
Correct.
Okay. Would reviewing your report refresh your recollection as to whether you completed a tag?
I can take a look.
But may I approach?
Yes, sir.
I'd like to see it.
I'm sorry.
It's okay.
First, show opposing counsel for the record. Judge, may I approach?
Yes, sir.
Officer, I'm handing you a report. Tell me if you recognize that.
I do.
Is that your report?
It is.
Take a moment, review it. Let me know if it refreshes your recollection as to whether you completed a toe tag.
Okay. I don't believe it says on there.
I'm gonna direct your attention to the very last line here. This says the inventory search was documented on body worn camera.
Correct.
Does that mean that there is not a toe tag that's completed?
That is incorrect.
Okay, so your testimony is that it's inconclusive as to whether there's a toe tag completed?
Correct. Unless I can see it, I can't testify to it.
Okay, but you wrote in your report, the inventory search was documented on body worn.
Correct.
And it's fair to infer from that that it's not documented anywhere else.
I'm not going to agree with that.
Okay. But you, at this point, you can't testify to whether you completed a toe tag.
No.
He's answered, Judge, he's answered the question like multiple times. I don't know how many times.
I'm moving on. I'm sorry, Judge.
No, you're fine, Mr. Sullivan.
Do you recall coming across several pairs of shoes in the car?
I don't recall.
No list that you can refer to?
No, sir.
Do you recall coming across an umbrella?
I don't. I can't testify to that. I don't recall.
No list that you can refer to?
No.
You would agree that the purpose of an inventory search is to document the contents of the vehicle,
Correct.
so that when the vehicle is released to the owner, this prevents or protects the department from liability for stolen or missing property.
Yes.
And so the owner can see the list of things that's been inventoried at the time that the car was impounded. You would
Yes.
agree? And you can't tell me at this point whether that list was ever generated.
I can testify that it's per my report that it was documented on body worn camera.
But that's not, your testimony is that's not the police's policy, correct?
Objection, he's already mentioned, Judge, that he cannot testify to that.
That he can't testify to the policy?
No, not that he can't testify. He can't testify to everything that's in the policy. I mean, it could be hundreds of pages long. He can't testify to everything. He's testified to what he knows in his personal knowledge.
Hold on one second. Mr. Sullivan, your response to the objection?
Judge, I'm not asking about the entire contents of the policy, just sort of one provision of the policy, which I believe he's already testified to, and so I'm just looking for clarification. I believe his testimony was that policy dictates that he completes a tow card.
Your objection is overruled. You may respond to the question if you recall the question.
Can you repeat it, please?
Your testimony earlier is that the police policy is that you complete a tow card.
Correct.
The police policy is not that you document the contents of the vehicle via your body camera.
I can't speak to the specifics of the policy, whether it includes the body camera or not. Like the prosecutor states, the policy is quite extensive.
Are you aware of any instances when somebody goes to pick up their car from the impound lot, and upon picking up their car, they also receive a copy of your body worn camera? To your knowledge, has that ever happened?
Objection, relevance.
Judge, I'm again, my questions are about the purpose and the intent of an inventory. And if the officer doesn't quite remember whether or not the policy allows for the body worn camera to be substituted for a tow card, well, then maybe the officer will remember that sometimes people receive the body worn camera in lieu of a tow card
And
when they
I'm
go to pick up the car.
Respectfully, I'm also going to be objecting as to speculation.
I asked if he had, to his knowledge, I'm not asking him to speculate, I'm asking
As
to
to-
his knowledge. If he says he doesn't know, then I'll move on.
Your objection is overruled. The specific question is, are you aware of any instance where someone goes to retrieve their car, right?
That was my question.
A specific instance, not some random general question, correct?
I'm not asking him to speculate.
Right.
I'd prefer that he testify whether he's aware or not.
Do you recall the question, Officer Stimpen?
I'm not aware of that happening.
Officer, in your experience, when you complete a toe tag, you enter that tag into evidence, correct?
It's entered into the Columbus system.
Okay, it's turned over to the prosecutor.
I can't testify to that. I can just testify that once it's logged, it goes into the Columbus system.
What is the,
The Columbus system is was the report writing system.
the report writing system?
Correct.
So it's entered into the same file with all of the reports and other evidence which is generated in the case.
I'm not sure. Once I enter it, I'm not sure where it goes. I can tell you that it gets impounded or inputted into the police database.
And that's per your policy, is that it gets entered into the database.
Our policy is that it gets entered. Yes.
Judge, may I
Approach whom?
the witness?
Thank you.
Sorry, I've previously shown to opposing counsel a video, which I'd like to approach the witness with.
You may approach.
Officer, I'm showing you a video.
Okay.
Do you recognize this?
Just for the record, I'll stipulate to the introduction of any video. In relation to this case, in regards to his body worn camera, I'll just
Stipulate to the court receiving the body worn camera video.
Correct.
Judge, I wasn't intending on admitting it into evidence. I was just going to ask the officer a few questions about the video. Are you able to identify this video?
Yes,
This is your body worn camera.
it appears so.
And this is your conducting what you call an inventory search of the vehicle.
Yes.
Here we see you opening a shoebox.
Okay.
Is that fair to say?
I'm not sure what that is. It's a box, I can tell you.
Okay. When you open that shoebox, that's a place where you're anticipating there might be things hidden.
I'm not sure hidden.
Okay. You want to make sure that there's no narcotics in the car before you impound it?
No, that's not a point of an inventory search.
Okay. I'm going to continue playing the video.
Okay.
Okay, in the portion of the video that I just played, you open a toiletry bag, correct?
I'm not sure what that was.
It's a small compact bag in the back of the car.
Yes.
You unzip it, you shine a flashlight around inside, and you said brushes.
Okay.
Is that correct?
I couldn't hear.
Okay. You didn't write down any of the things that you found in the bag?
Not at that moment, no.
And you didn't, certainly didn't inventory the entire contents of the bag?
I can't testify to that.
You didn't remove anything from the bag?
I don't recall.
In that portion of the body-worn camera, you're opening the compartment where the spare tires kept, correct?
Correct.
You removed something from that compartment and you threw it into the truck.
It looked like something fell.
Okay. But do you know what that item was?
No.
You didn't document it in a list anywhere?
I can't tell you if I did or not.
And then in the video we watched you close the trunk.
Correct.
Testified on direct that you ran a lean search to determine the owner of the weapon that you found.
Yes.
And the owner was a Crystal Watley.
Yes.
And that's consistent with something that Mr. Michaud told you, correct? Mr. Michaud told you that that his girlfriend borrowed the car.
Objection, that was never raised at any point during any testimony, from my knowledge. He learned that from conducting a lean search, is what I recall, Judge. I believe that's a misrepresentation.
Judge, my understanding, and I've been practicing for a few years, is that I'm allowed to ask questions on cross-examination, which extend beyond the scope of the direct examination. Defense attorneys oftentimes do independent investigation, and this leads to questions that I sometimes like to ask on cross. And so please correct me if I have that wrong, but I don't think I'm limited to the scope of the direct examination.
Judge, I'm just saying, I think he's misrepresenting his words. He said he learned that information based off of a lean search, is what I recall. It was never through the words of anybody else. That's what the testimony today has reflected, and that's, from what I recall, that's what he said. I'm incorrect, I withdraw, but pretty sure that's what he said, that it was, he learned that through a lean search.
Your objection's overruled. I believe the question was the lean search and through something Mr. Michaud said to you?
I'll back up and lay further foundation, Judge. You had a conversation with Mr. Michaud, correct?
Yes,
You confronted him about the gun that you found.
I spoke to him, yes.
He told you that he believed it was his girlfriend's gun.
I don't recall. If I can take a look again at my report, I might be able to tell you. Okay, I believe I'm ready. Can you repeat it just so I make sure I answer it correctly?
My question is, did Mr. Michaud tell you that he believed the gun belonged to his girlfriend?
Let's see here. Yes, he said that, yes, he stated that the gun may belong to his girlfriend,
Okay, I'll take it over.
Miss Wadley.
So that was consistent with what you learned in Lee.
I'm sorry?
That was consistent with what you learned in Lee.
Correct.
Your testimony earlier is that you don't recall whether the center console was open or closed when you conducted the search.
Correct.
Would an opportunity to review your body worn camera refresh your recollection as to whether you had to open the center console?
Yeah, we'll take a look.
Does that refresh your recollection?
Yes, sir.
Do you recall whether you had to open the center console in order to locate the gun?
In that video, I had to open.